This is the fourth session. Does the U.S. Constitution hand the federal government unconstrained authority to control the border and restrict immigration? I'm Tom Bray, contrary to the program. I'm not Tim Bray, but I guess I'll do. Shika and I worked together in previous incarnations, and I appreciate the opportunity to be here. It's been very interesting, and I'm sure that we'll have a lively discussion today. So first up is I'm going to introduce the panelists before they actually talk, one at a time. And we'll have 20 minutes for each of the main panelists, 10 minutes for the discussion, for each discuss it. And then they can question each other for 15 minutes or so, and then we go to the audience for questions. Would appreciate it if you actually ask questions and not make lengthy commentaries about things. We want to spread it around as much as we can in the limited time that we have. So first up is Ilya Somin, professor of law at George Mason. His research focuses on constitutional law, property law, and the study of popular political participation and its implications for constitutional democracy. He's the author of Democracy and Political Ignorance, Why Smaller Government is Smarter, and The Grasping Hand, Kelo versus City of New London, and The Limits of Eminent Domain. Professor Somin was the John M. Olin Fellow in Law at Northwestern. He was clerk for the Honorable Judge Jerry Smith of the Court of the Fifth Circuit Court of Appeals. He has an MA in Political Science from Harvard and a JD from Yale Law School. Professor Somin. No, as we go.
Okay, got it. So I'd like to thank the Reason Foundation and Michigan State for organizing this exciting event. And the thesis that I outline in my paper is actually pretty simple, albeit by today's standards it seems very radical. And that is that there is no general power of the federal government in the Constitution to restrict immigration. As I said, this is something that is almost uniformly rejected by people today. Most people simply take it for granted that this sort of power exists. However, I am far from the first person to suggest the radical idea that it doesn't exist. Such previous radicals as James Madison, Thomas Jefferson, and a good many others in the founding era said much the same thing. So this is more of restoring or excavating an old idea than presenting some kind of new idea of my own. What does it mean to say that there is no general federal power? It just means that the federal government does not have the authority to exclude people from the United States simply because they're not American citizens, or they were born abroad, or other similar characteristics. There can be, I think is a power to exclude some categories of foreigners for other kinds of reasons. For instance, if they're an invading army, under the power over national defense, and so forth, but there is no general federal power over immigration. In the paper, I also discuss the question of, well, what would state power over immigration look like if we restore the original meaning of federal power? I'm going to skip over that topic in the presentation, and I may well just also exclude it from the final version of the paper as well, because I think it may be dealing with federal power is more than enough ambition for one paper at least. In the first part of the talk, I'll talk about several standard theories that are offered for why there is a general federal power over immigration. I'll point out the flaws in them. And then in the last part, I'll discuss why we should even care about this issue today. After all, while I argue that under the text and original meaning of the Constitution, there is no such power, I certainly grant that it has been enshrined in Supreme Court precedent since the Chinese exclusion cases of 1889. And I certainly recognize the Supreme Court is not likely to overturn those decisions anytime soon. So you might think, well, this is just a purely academic interest, like figuring out how many angels can fit on a pin or something like that. But I'm going to suggest that it does actually have some practical implications for the near future, even if the Supreme Court is not going to go my way anything like completely anytime soon. When you look at the text of the Constitution and look for power over immigration, it is notable by its absence. There's a lengthy and detailed list of congressional and presidential powers in Articles 1 and 2 of the Constitution. The power to restrict immigration just isn't on that list. This is not because they only included a small number of very important powers and left everything else to implication. To the contrary, there's a pretty detailed list. It includes even such fairly minor powers as the power to establish post roads and the power to create standardized weights and measures. Yet power over immigration is not listed, or at least it's certainly not specifically listed. Despite this, going back to at least the 1790s, there has been a substantial cottage industry of trying to say, well, you can find this power in one of the other powers which are listed. Perhaps the most obvious possible source of authority is the power over naturalization. The Constitution does give Congress the power to create uniform rules of naturalization. But both in the founding era and even today, it is easy to see that the power to grant citizenship is distinct from the power to grant entry. Both then and now, people recognize that one can grant citizenship to people who have not entered the U.S. and perhaps never will. For example, children of American citizens born abroad. On the other hand, it was certainly recognized that people who are not citizens could enter the U.S., and they did, and of course the same thing is true today, so it's very unlikely that this power of naturalization is actually a hidden power over immigration as well. Another potential source is the power over foreign commerce. Article 1 of the Constitution gives Congress the power to regulate commerce among the several states and also with foreign nations. Some people, both in the founding era and obviously today, argue that this is also a power to restrict immigration. Immigration is a kind of commerce, but the dominant view at the time of the founding, and actually for many decades thereafter, is that the power over commerce is not a power over mere movement. It is a power to restrict the movement of so-called articles of commerce, trade in various goods, possibly trade in services. The services part was actually much disputed in the 18th and 19th century, but not the mere movement of individuals. If there was a power to restrict the movement of individuals because of the Commerce Clause, that would mean that there would also be a power of the federal government to forbid interstate movement by American citizens. Because the very same clause, indeed the very same phrase, includes both power over interstate commerce and power over foreign commerce. Nobody at the founding era, and again for many decades thereafter, imagined that there is a power that Congress had to forbid Americans from moving from one state to another. And by the same token, if it doesn't allow a ban on interstate movement, it also doesn't allow a ban on international movement either. Now, I hasten to add, under today's extremely broad interpretation of the Commerce Clause, you could ban probably both interstate movement and international movement, but that, with today's very broad interpretation, does not match up at all well with either the original meaning or indeed the way it was understood really until well into the 20th century. I can talk more about those precedents and questions. Some people, including my friend and former student Josh Blackman, who's going to speak later, they say, well, there's not a specific enumerated power. However, it can be imputed from the necessary and proper clause. Is what the necessary and proper clause says is that in addition to specifically enumerated powers, Congress also has a catch-all power to make laws which are necessary and proper for carrying into execution other authorities that Congress and the federal government generally might have, and therefore, while restricting immigration is not itself one of the enumerated powers, it's something that can be used to help carry into execution other powers. For example, while immigration itself might not be commerce, restricting immigration might be useful in regulating both interstate and foreign commerce, because immigration pretty obviously has a significant effect on those things, and therefore it would be useful to that purpose. If you interpret this power broadly, then you can use the necessary and proper clause to do pretty much anything. Justice Antonin Scalia once famously called the clause sort of the last refuge of constitutional scoundrels or words to that effect, because if you interpret necessary and proper very broadly, you can sneak in pretty much anything there. And indeed, in the early and famous case of McCulloch versus Maryland, the Supreme Court said that necessary just means useful and or convenient, which could be almost anything. But at the founding era and even today, actually, both courts and constitutional authorities of other kind recognize that necessary and proper are actually two separate requirements. Something which is necessary might still not be proper. What does proper mean? Well, the Supreme Court, again in McCulloch versus Maryland, and other constitutional commentators early on, including Madison and others, emphasized that in order to be proper, the additional power that goes beyond the enumerated power has to be merely incidental. It can't be what Chief Justice Marshall in McCulloch called a great and independent power that's added, that's a massive additional accretion of federal authority. How do we determine whether a given power is incidental as opposed to great and independent? Well, it's far from clear. However, this particular instance is a pretty easy case. It's pretty obvious that the power to restrict immigration, indeed the power to completely ban it, is a great and independent power. It is a massive addition to federal authority, and therefore, if anything might be necessary but not proper, this is a great example of it. The Supreme Court actually in 2012 famously ruled in the Obamacare case that the power to force people to buy health insurance or other products is necessary but not proper. The power to force people to buy things, while significant, is actually not nearly as great and independent as the power over immigration is. So by the same logic, I think it applies here. Some people argue that, and this actually argument was raised in the founding era as well, that a power over immigration can be imputed from the migration or importation clause. This is a clause of the Constitution which obviously is no longer operative, but it said that the federal government will not have the power to ban the migration or importation of such persons as state governments might want to admit until 1808. The obvious purpose of this was to prevent Congress from banning the slave trade until 1808. But because the word migration is in there as well as importation, the thought is, well, if they have to restrict the power over migration, then that must mean that there was a power over migration to begin with. I think this doesn't at all follow for two reasons. First of all, many of the founding fathers, including James Madison, specifically insisted, he said this in the Federalist Papers, that the migration or importation clause should not be interpreted as a power to ban the voluntary migration of immigrants, free people, and that it was really all just a euphemism for slavery. They didn't want to explicitly mention the word slavery. They were embarrassed about the subject, and therefore they used these euphemisms. Secondly, even if you say, well, migration must refer to some category of voluntary migrants, that does not mean that it refers to a general power over migration. Rather, what it refers to is a power over those voluntary migrants who at the time were considered as articles of commerce, much like slaves were as well. And indeed, such a significant category did exist. Indentured servants. This was a very important category of migrants in the 18th century, and in the parlance of the time, I know this is very insensitive, but in the parlance of the time, they were thought of as articles of commerce in much the same way as slaves, because they were legally required to work for their masters for 7 years, usually after coming to the U.S., and to do so for no pay other than room and board. So this is a category of voluntary migrants that the migration portion of the migration or importation clause likely refers to. There are some people, actually including some modern commentators, including Michael Ramsey, who will speak later, who have argued that maybe the power to exclude migrants is an executive power, not a congressional power, and they contend that in the 18th century, it was generally understood that executives would have the power to exclude foreigners, that the King of England perhaps had this power, for example. I think it's striking that this argument was not advanced in the founding era, like when the Federalists wanted to defend the Alien and Sedition Act in 1798, the only congressional legislation for many decades which established any kind of broad exclusion of migrants. Moreover, we should not assume that the founders believed that any power that European monarchs generally had, that therefore the president must have, much to the contrary. For example, the Declaration of Independence specifically chastises the King of England for endeavoring to prevent the population of these states by preventing foreigners from migrating to the colonies. The rebels clearly believed that the king was exceeding his authority. Whether or not they were right under the English unwritten constitution of the time, it certainly suggests that they did not take for granted the idea that the American executive should have whatever powers the King of England had by virtue of being the executive within the British Empire. When the Supreme Court finally endorsed a general power over immigration in 1889 in the Chinese exclusion cases, they actually did not use any of the theories that I just enumerated. Rather, they said, well, there isn't necessarily a specific enumerated power, but there doesn't need to be, this is a power that's just inherent in the nature of sovereignty, and all sovereigns must have this power somewhere, so it doesn't need to be listed. I sometimes like to call this the it's got to be in there somewhere theory, right? We maybe can't find a specific source for it, but it's just got to be there because sovereigns just necessarily have to have it. I think there's a variety of flaws with this, but the most obvious is that we can't assume that the Constitution just implicitly assumes that all powers that are inherent to sovereigns or that were thought to be inherent to sovereigns in the 18th century must be in there somewhere. If that is the case, then there would be no point to enumerating such powers which are more fundamental to sovereignty, like the power to declare war, the power to raise armies, the power to tax, and so forth. All of these actually are specifically enumerated, which suggests that it was not taken for granted that powers that are fundamental to sovereignty in some way have to be enumerated. Moreover, we are actually a system of dual sovereignty with federal and state sovereigns, as Peter Scarry rightly emphasized yesterday. And in the founding era, it was generally understood that the power over to exclude immigrants was actually within the state. So, and states actually did have various laws excluding immigrants of some kind, primarily people they thought might turn out to be quote-unquote paupers or public charges and the like. So even if you believe that this power has to be inherent in the sovereign somewhere, it was at the time thought to be within the power of state sovereigns, not federal sovereigns. I also think that it's actually very dubious that sovereigns must have this particular authority by some law of nature or whatnot. The federal government actually got along quite well without this power for the first 100 years of its history. So I think it's very questionable. That this argument, and it has some very obvious significant flaws. Finally, some people today argue that there is this power to exclude migrants under Congress's authority to define and punish violations of the law of nations. I'm not going to go into detail on this in the initial presentation, but I am happy to talk about it in the questions. In the last few minutes that I have, I would like to briefly talk about, well, why should we even care about this today, or at least why should anybody who's not a constitutional law scholar trying to get tenure care about it? After all, as I said, the Supreme Court is very unlikely to overturn the Chinese exclusion cases anytime soon. Obviously, many people would argue that they shouldn't overturn long-standing precedents, even ones like these, which are both logically flawed and also heavily influenced by the racism of the time towards Chinese, where you even see this in the opinion where they discuss the hordes of invading Chinese who can't possibly be assimilated into the American way of life and who are a threat to us. But nonetheless, despite the bad odor of these cases, it's unlikely the Supreme Court will overturn them in the foreseeable future. So why should we care? I would say for several reasons. One is that the issue of whether Congress and the federal government generally have power over immigration is not the only question at stake here, because on top of saying that the federal government has this power, the Supreme Court has also said, most recently in the travel ban case, that this power is so great that it overrides what would otherwise be normal constraints on federal power, such as constraints on unconstitutional discrimination, constraints to the Bill of Rights and the like. All of those are said to apply with much lesser, if any, force to immigration restrictions and to other exercise of federal power. We saw this dramatically on display in the travel ban case, where the 5-4 majority said that essentially an action that was obviously discriminating on the basis of religion and would have been struck down as such in almost any other context. In the context of immigration, it goes through because there's much more deference. If federal power over immigration, far from being above and beyond other federal powers, actually rests on much more dubious foundations than those other powers do, then at the very least, it should not have the special status where it can override the protections of the Bill of Rights, restrictions on racial, ethnic, religious discrimination, and so forth. And overruling that doctrine is very much within the realm of possibility in the near future. We already essentially had 4 votes for it in the travel ban case, so that could occur. Secondly, even if you don't overrule the Chinese exclusion cases entirely, there are many ways to limit them. For example, you might say existing immigration restrictions go through, they're sort of grandfathered in, people, or at least the government, have relied on them, but new ones will be subject to a higher level of scrutiny. We're going to take a close look at this to see whether it can be rationalized in any way other than a virtually unlimited federal power over immigration, and there's other kinds of intermediate options as well. More generally, I think the movement to strengthen constitutional protection for immigrants, if it's going to succeed at all, has to operate in much the same way as other previous successful constitutional movements. That is, have a parallel track of both legal and political action. This is how the civil rights movement succeeded, more recently the gay rights movement, the women's rights movement, and quite a few others, that you pair political action with litigation directed at the idea that, that the current doctrine underprotects an important population or gives the government too much power. And my hope is that over time, such a movement can develop and succeed. It actually already has begun in various ways. The idea that federal power is completely unconstrained has already been chipped away in various Supreme Court decisions. I fear that we are at a relatively early stage of this process. We are where the civil rights movement perhaps was in 1910 or 1920, or the women's rights movement in, say, 1940 or 1950. But that's still not nothing, and further progress can be made. In the meantime, I'll leave you with the thought that while everybody, or almost everybody for many years, has thought that this power must exist in the federal government somewhere, in reality, when you take a close look at it, it looks very much like an emperor that is walking around with no clothes, or at least it's much more scantily clad than we have been brought to believe. Thank you so much.
And on that unclothed thought, we moved to our first discussant, John Eastman, the Henry Salvatore Professor of Law and Community Service at Chapman University, Fowler School of Law. He also served as dean there from June 2007 to January 2010 before stepping down to pursue a bid for California Attorney General. He had served as a law clerk for Justice Clarence Thomas and Judge J. Michael Levy at the United States Court of Appeals for the Fourth Circuit. He earned his J.D. from the University of Chicago Law School and a Ph.D. and M.A. in government from the Claremont Graduate School. Professor Eastman.
Thanks very much. Well, thank you all for coming out early on a Saturday morning, and thanks also to the Reason Foundation and MSU for hosting this fine conference. I've learned a lot. Of all of the things Ilya said, the thing I agree most significantly with is his is a very radical idea. It seems to me incumbent upon somebody proposing such a radical idea to be scrupulous in the accuracy of the of the sources he relies on to advance the thing. And what I'm going to take issue with is this appears to me to be more an exercise in finding things that sound like to support the thesis rather than grappling with the underlying authority. And I want to then kind of explore why I think that's true, because I think confronting the opposite reading of those sources and trying to explain more thoroughly why those sources actually support his thesis, I think would advance or strengthen the cause of his paper. But as of now, I don't think it's there. Let me give I think the most stark example. He relies on the criticism of the king in the Declaration of Independence as blocking migration into the country. That, you know, you tease those words out and the words are there. It's almost like we did a Google search for the right words to support the thesis. But the challenge there is that he rejects the policy of populating. And Ilya takes that in to say that the founders all agreed that he had exceeded his authority in doing that. There's no hint in the Declaration of Independence about whether he had the authority to do this or not. The challenge to the king that it was bad policy, that he was interfering with what they wanted to have as good policy. And those are two dramatically different things. In fact, if you look more deeply into what the charge actually is and what it's based on, it's tied to the king's royal orders in 1772 and 1773, which Ilya, to his credit, cites. But those orders didn't deal with migration, they dealt with naturalization. In fact, the king's orders have connected the naturalization power and the immigration power in the very way that Ilya elsewhere in the paper argues it doesn't exist. Those orders forbade the colonies from naturalizing aliens, banned the passage of any laws facilitating that purpose, and the founders took that as by banning us from naturalizing folks, you have effectively refused, endeavored to prevent the population of these states by preventing foreigners from migrating to the colonies and refusing to pass laws that would encourage their migration. So the dispute is one over policy, but it's all a policy where the king's orders themselves are tied to naturalization. So I want to go back to, I think, the clause in the Constitution that most directly deals with this issue. And I think that's the power of naturalization. Naturalization, to be sure, is distinct from immigration. The question, the significant question, and one that's not addressed in Ilya's paper at all, is immigration a subcomponent of naturalization? Can it exist without naturalization? Of course. Can we naturalize people without immigration? Of course. But in the general thought, is immigration a lesser included power to the power over naturalization? And I think that's a very significant claim, and it's one that ought to be addressed, and it yet isn't. And if that's true, of course, if I have the power of naturalization, then Congress clearly has the lesser included power to regulate the migration of folks who would ultimately be naturalized. And I think it's much more likely that that's the way they envision that power. He also relies, as I said earlier, it's a radical idea, but he's not the first. He's in good company. Jefferson and Madison took this position as well. Not true. Not true remotely. The evidence that supports that in his paper is their opposition to the Alien and Sedition Acts. Now, the Alien and Sedition Acts don't talk about the right to exclude people coming into the country at all. It was the power to deport people who were already here. And those are radically different things as well. And to say that Jefferson and Madison, in objecting to the exclusive power that Congress had conferred on the president to remove people from the country, that their objection to that implies an objection to any power in the federal government to restrict the entry in the first place, I think puts a lot more weight on those Alien and Sedition Act opposition papers than can possibly be warranted. There's another passage dealing with the migration and import, or the non-importation clause, and he attributes to Madison that this clause did not limit, did not confer any power on, to restrict immigration. Again, not true. First of all, there's something odd going on here. There's no discussion at all in the Federal Convention about the addition of the word migration to the migration and importation clause. Ilya says in his paper that that meant that this was a euphemism. The entire clause was therefore a euphemism to avoid use of the word slavery. The language where that existed was in the word person. that they use the word person in the power of the migration and immigration clause, not the word migration. Madison's claim to the contrary, that migration was part of this as well, comes 32 years later in a letter. It's not part of the Federal Convention. But what's interesting about that letter in 1819 is what else he says. And he goes on, let me see, where is it? He goes on to say that, that the issue of whether we could control immigration was not part of the migration clause, that we recognize that that extended not just to indentured servants as well, but to free citizens. And the power to restrict it was not limited to that they didn't have any power over immigration. It was that they could not impose a tax on the immigration of free persons that would impose a barrier to it. There was no discussion whatsoever that this was a limitation on Congress's power over immigration. Then you go back and you look at the kind of founding principle. I think the truly most radical idea in the paper is the one that he didn't go into at length here, and that is the power of the states to impose restriction. And he teases out of Caroline Product's footnote 4, a very, very famous footnote in Supreme Court jurisprudence, where we get the language of discrete and insular minorities. And that the protection of minorities would impose, not just on the states, but by implication on the federal government as well, a limitation on foreigners, because foreigners are a discrete and insular minority. They have no political power here, and therefore any restriction on foreigners would be subject to strict scrutiny. And this, I think, is truly the most radical of the propositions, because it undermines the very notion of a political regime. It runs contrary to everything that's in the Declaration of Independence. The right of a people to decide for themselves what kind of government they're going to have. That representation flows to that people, not to folks who are not part of the body politic. This would really completely alter the very notion of representative government and government by consent. The folks who are not part of the political process have to be assured of their right to representation in that political process as a matter of constitutional law. By that thesis, there would be this is really an attack on the entire Westphalian system. We would have no borders, we would have no political regimes, we would have no understanding of representation of a body politic, because there would be no way to limit who's part of the political regime. It truly is radical. And I use this to kind of go back in as a backhanded way to why I think that the strongest argument is in the naturalization clause, but why I think there's an even stronger argument to be made in the power to define and punish violations of the laws of nations. That one of the inherent aspects of the law of nations, and you go back through the entire history of international law, Vattel, Blackstone, Pufendorf, they all recognized that there was no right to go to any other sovereign or to any other nation but with their permission. That's one of the deep background principles. And for Congress to be able to define when we're going to punish that, and we kind of reverse it, when you're authorized to come in, but when you're authorized to come in, it necessarily implies the flip side of the same coin, when you are not authorized to come in. And if part of the law of nations was for any sovereign to define that, Congress, given the explicit enumerated power to define and punish the law against nations, would allow them to define who can be coming into the United States, become part of the body politic, both on an interim basis as lawful residents, and then on a more permanent basis as naturalized citizens. These things then feed off of each other. And the notion that therefore there is not an enumerated power given to Congress to regulate immigration, the beginning process of that ultimate authority to issue naturalization authority, particularly when combined, as I think Josh Blackman's going to articulate, with the necessary and proper clause, I think is a very uphill hurdle. Not just that the Supreme Court's not going to revisit the question anytime soon, but I'd be surprised that they would revisit the question and come out in another direction ever.
Thank you, Dr. Eastman. Already clear the Supreme Court's got enough work, but
Hey, John, get in the mic.
if we get into this, good luck. Okay, our next speaker is Josh Blackman, professor of law at the South Texas College of Law at Eastman, who specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. Professor Blackman is the author of Unprecedented, the Constitutional Challenge to Obamacare. Mr. Blackman was selected by Forbes magazine for the 30 Under 30 in law and policy. He is the founder and president of the Harlan Institute, the founder of Fantasy SCOTUS, which may be applicable to today's subject, and the Internet's premier Supreme Court fantasy league. He blogs at joshblackman.com. He clerked for the Honorable Danny Boggs on the U.S. Court of Appeals for the Sixth Circuit and for the Honorable Kim Gibson on the U.S. District Court for the Western District of Pennsylvania. He is a graduate of the George Mason University School of Law. Professor Blackman.
Thank you very much. The topic of this panel is, does the U.S. Constitution hand the federal government unconstrained authority to control the border and restrict immigration? My good friend Ilya, who was my professor in law school, says no. In fact, the federal government has zero power over immigration, none whatsoever. I'm labeled as yes, not quite my position. So I'm actually more grateful to Ilya than is my good friend John. I had always simply assumed that the power of immigration was inherent. What does that mean? The Supreme Court said in a number of cases involving exclusion of Chinese people that as a matter of sovereignty, the government has a power to exclude people from our borders. I simply assumed that was correct. I'd never really given it much thought. But there's a tension. A bedrock principle of our republic is that Congress only has those powers that are enumerated. Now, I know there are not many lawyers in this room, so I'll explain that. Sorry, slightest bit of cold. The state governments have what's called a general police power. That is, they can do almost anything they need to do to protect the health, safety, welfare, and public morals of the people. There's some limitations. In contrast, the federal government is a government of limited and defined powers. For example, they can regulate commerce, they can coin money, they can regulate postal roads. There are certain things they can do that are enumerated. So whenever you ask, does the federal government have a power to do X, you first check, is that power in the Constitution? And I think if you look at the Constitution, I agree with Ilya, there is no clause saying that Congress has the power to exclude aliens. You have other clauses that speak to immigration, but nothing specifically there. Where I part company with my former professor is I don't quite stop there. I look at the clauses in perhaps a little bit more of a flexible fashion. And the primary clause I'll talk about is the necessary and proper clause. John mentioned a moment ago that Madison and Jefferson don't quite endorse Ilya's position. I agree with him on one aspect, but there was a huge debate on the necessary and proper clause in the early years of the Republic concerning the Bank of the United States. Now, we have several provisions of the Constitution. Congress can regulate commerce. Congress can borrow money. Congress can lay and collect taxes. Congress can coin money. These are all financial related tasks. But there's no provision saying that Congress can charter a federal bank. In the very early years of our republic, in the Washington administration, there was a huge debate about the Bank of the United States. In Congress, Representative James Madison said that Congress cannot establish a bank. It is not necessary. Right? It is not essential to have the regulation of commerce for Congress to have a bank. Madison lost that battle, and Congress approved the Bank of the United States. The bill goes to President Washington. He asks his cabinet for their opinions. He asks his Secretary of State, Thomas Jefferson, what do you think? And Jefferson gave an opinion very similar to that of Madison, that it wasn't necessary, it wasn't essential to charter the bank. In contrast, you have Alexander Hamilton, the Broadway superstar, who was the Secretary of the Treasury and who had the idea of the bank in the first place. And he gave Washington a memo that was much more supportive of the bank. He said that the word necessary doesn't mean essential, it can mean useful or expedient or something of that nature, that it helps the government out, right? That it's useful to have a bank in order to regulate interstate commerce. Washington, for one way or the other, sided with Hamilton. And that was a fairly authoritative statement over the scope of Congress's what were called implied powers early in the Republic. Now, the initial charter of the Bank of the United States expired, and about 20 years later, Congress renewed the bank, and its constitutionality was challenged in a famous case called McCulloch v. Maryland. Chief Justice Marshall adopted, in large measure, Hamilton's opinion and said the bank was a necessary and proper means of executing the federal commerce power, for example. He expanded on Hamilton a bit, but not important here. Why am I talking about a bank in the 1800s when I should be talking about immigration? Well, this was an early explication of what federal power is. This is not the Chinese exclusionary cases in the 1880s. This is George Washington and Alexander Hamilton making a very early decision on the scope of federal power. And the framework we have here is twofold. Ilya is correct. It's not enough for a federal power to be necessary. It also must be proper. And this is an important aspect that most law professors simply ignored, which is why the Obamacare decision in 2012 came as such a surprise. Where Ilya and I part company is why the federal immigration power is both necessary and proper. So we don't have clear guidelines of what makes a federal power proper, but we have certain indications from case law, right? It can't be a great substantive and independent power. What does that mean? It's got to fit within some framework. So what do we have to go on? In the Obamacare decision, the Chief Justice Roberts explained that the mandate to purchase insurance was indeed unprecedented, the title of my first book. Never before had Congress attempted to mandate the purchase of a commercial product, right? So I call these guardrails. One of the guardrails of the proper framework is this some sort of novel power that's never before been exercised? With respect to immigration and the power to exclude, it's not that novel. It's been around for 100 years. Unclear if the federal government did it at the time of the founding. We can go back and forth, but it was known. The King of England did it. This was a power that's fairly long established. So I don't think it's any sort of novel, unprecedented power. The second aspect concerns what's called commandeering. In the Obamacare decision and other cases involving gun control laws, the court has said that Congress can't force state officials to take any sort of action, that is not a proper exercise of federal power. With respect to immigration and the power to exclude, there's no commandeering of state officials at all. It's employed purely by federal officials, and in fact, you see the sanctuary cities cases, you can't force state officials to engage in federal immigration enforcement. I think those cases are probably rightly decided. The third one I think is most important. Does this federal power commandeer individuals as U.S. persons, right? The Obamacare mandate forced people to buy insurance, and that was a novel power that went to the heart of people. Immigration power to exclude doesn't affect Americans directly, at least, and this goes to John Eastman's point. Immigration power to exclude affects Americans indirectly, without question, right? People are separated from their families and their friends, yet no argument for me there. But it doesn't act directly on U.S. persons. I think an underlying current in Ilya's work, and he's written about this elsewhere, is that there is no federal power to have a border. None. People have a right of movement, of locomotion, as he calls it. And that even people who are not part of the body politic still have some sort of right, from whatever source, to enter the United States as a matter of constitutional law. I think that's a very difficult concept to square with a lot of law and a lot of tradition and a lot of custom in our country, even if there's no express power over it. What I'm getting at is there's no express guardrail that's violated with the power to exclude. Therefore, I think it is a proper exercise of power. Once you agree with me on that point, it becomes an easy question. If Congress wants to have a naturalization law that's augmented by an exclusionary power, then I think that's a necessary and proper means of doing so. For example, Congress can say that if you're in the United States for X years, we will grant you naturalization. But in order to ensure that a certain pool in the United States to get used to being here and maybe contribute to the economy, et cetera, they can exclude people who don't fit their rules. Maybe it can be coupled with the commerce power, right? That if you have merchants coming to the United States, you want to make sure that people on their ship or stowaways can't come aboard. Okay, these are not perfect examples. They're not, I think, concrete. They're not perhaps even logically consistent. But the necessary and proper clause doesn't require such consistency. It's a very flexible standard. The alternative is that based on your Ilya's rubric, we would be the only nation in the world which lacked the power to exclude people. It's a hard standard to reconcile. John says it's radical. I don't like words like radical. I think people who challenge ideas are actually very useful because it makes me reconsider my own priors. But it'd be a very tough thing for me to swallow that we are the only country on earth that could not deny people entry into our borders. Now, that's over the legislative power, right? I think there's an enumerated power under necessary and proper clause. The second element that I want to discuss concerns the executive power. And this is also an area where I sort of changed my mind along the way. The Supreme Court said in a case from the 1950s that the executive, the president, has the own inherent power to exclude aliens. As a matter of perhaps war-making powers, right? Let's say there's a declaration of war against Germany or Japan. I think at that point the president would have an activated inherent, no, not delegated, but it would have an executive power to exclude. Let's say that there is an invading army coming on our shores and Congress hasn't declared war yet, like the Barbary pirates show up in Manhattan Harbor. I think at that point President Jefferson could say, you're not coming aboard, you're not coming into our shores. I think I'm okay with that. But as a general power, I don't think the executive has the independent authority to exclude aliens. And there was an incident in the time of King George in the 1780s and 90s. Did King George have the power to Parliament? He didn't have the Parliament to do so. I think that's a fairly authoritative explication. So I think the president needs a delegation of power from Congress in order to exclude. Now, once he has a delegation of authority, I think he can use that exercise fairly broadly, which is what was at issue at the travel ban. Ilya and I disagreed on the travel ban quite a bit, but one basic premise of this case is that for purposes of immigration, which is uniquely federal power, the president and the executive branch and the federal government are treated uniquely from other elements in our government, right? Why is it that the court would not hesitate to rule against a mayor, for example, made anti-Muslim statements, but they had a lot of difficulty ruling against the president? The president serves a unique role. He's delegated powers under the Constitution and under the statutory law to take certain actions concerning immigration. And when he exercises those, courts should be deferential. Now, I'll end on a positive note. I do think Ilya serves as a very valuable function here by making us all challenge our assumptions. So for example, John Eastman's presentation, I learned a little bit. I didn't know any of that stuff about the grievances in the Declaration, right? I learned a lot from Ilya's paper on power of locomotion. When you challenge a norm, you often take a lot of arrows. You know, the person who goes first takes the arrows, which is fine. I take a lot of arrows myself. But even in the end, if we end up finding that Ilya is wrong, I think he is, I think we're all better off for it because we've learned a lot to reinforce our beliefs, which is why this sort of debate, this sort of forum, I think is quite valuable. Even where ultimately I don't agree with some of the fine speakers here, I always find myself better off for it having learned. I'll stop here, turn it to my good friend Mike Ramsey, and thank you all for your attention. You get the mic now.
Thank you for that civil discussion. Mike Ramsey is Professor of Law and Director of the International and Comparative Law Program at the University of San Diego Law School. He clerked for J. Clifford Wallace of the U.S. Court of Appeals for the Ninth Circuit and Antonin Scalia at the Supreme Court. He practiced international business law with Latham and Watkins. Professor Ramsey was Senior Articles Editor of the Stanford Journal of International Law. He was the author of the Constitution's text in Foreign Affairs. He obtained his law degree from Stanford University.
Well, thank you very much, and thank you for having me here, and to the sponsors, and thank you for the audience. Thank you to my panelists for that very interesting discussion. So I'm going to make 3 points, which I hope will be fairly quick. The first is that I want to interject something of a dose of reality here, although I think this has been acknowledged by the panelists to begin to some extent. But we are looking at something of an academic discussion here about the original meaning of the Constitution. Now, I'm very pleased to be involved in that kind of discussion. Most of my scholarship actually focuses on finding the original meaning of the Constitution. So I enjoy that sort of academic enterprise. But I think we need to keep in mind that as a practical matter, the court is not going to find gaps in federal immigration power, or power to exclude, based on structural considerations such as enumerated power. This is something that's been repeatedly affirmed in a long line of cases. It's not just something from a couple of sort of odd cases from the 19th century, but the Supreme Court has said repeatedly in cases throughout the 20th century and then right up through the travel ban case, that the federal government does have a comprehensive authority over immigration. It's deeply integrated into the legal system through the very comprehensive federal statutes that we have regarding immigration. And I think more importantly, there's just no political constituency for this idea whatsoever, because on the right, people want to have a comprehensive federal power over immigration. And on the left, people don't want to challenge the federal power over immigration through a structural attack such as enumerated power. In particular, they don't want to challenge it by restricting the scope of the Commerce Clause, which they favor as being quite broad for other reasons. So the attack on federal immigration power isn't going to come in the direction that so far this panel has mostly been discussing, and I'll elaborate on that a little bit more. I would like to say, though, parenthetically, that I think even from an originalist perspective, that this is not a promising line of attack, because originalism as an adjudicative theory, as opposed to originalism as an academic theory, for the most part, has substantial room for precedent. Only the most radical views of originalism would endorse turning against a long-standing precedent that's deeply integrated into the legal system. In particular, one that I think, and this I think is an important developing aspect of originalist theory, that when the Supreme Court, if the Supreme Court makes a mistake, creates a mistaken precedent, but it's a precedent that if the Supreme Court had gone the other way, very likely would have prompted a constitutional amendment. Then it's reasonable for us to accept that. I think this is a theory that's been developed by my colleague Michael Rappaport and by John McGinnis from Northwestern University, and I think this is a very powerful example. If the Supreme Court had ruled in the Chinese exclusion case in 1889 that the federal government had no power over immigration, and that we were in effect in a situation that, as John Eastman describes it, with no federal power over the border, I think that would have prompted a constitutional amendment. It didn't, because the Supreme Court went the other way. And for that reason, I think that kind of precedent, even if wrong, is not as troubling as some kind of precedents where the Supreme Court takes it upon itself to decide things quite contrary to what the vast majority of people prefer. Nonetheless, I think there are important questions about the scope of federal power, but I think these are the questions that are really on the table. Number one, will the Supreme Court read federal immigration law, much of which is somewhat confused and vague and not particularly helpful on some points? Will they read it broadly in favor of restrictions and exclusions, or will they read it narrowly in favor of immigrant rights, forcing Congress, in effect, to clarify what it really means? That was the question that was at issue in the Supreme Court case that was argued on Wednesday, where Justice Gorsuch and Justice Kavanaugh appeared to disagree on that point, and I think that's one thing that's very much on the table. Second thing that's on the table is, does the Bill of Rights grant constitutional rights to people who are outside the country? That is the federal immigration power restricted by the Bill of Rights when it's directed towards entry. There's no doubt that to some extent it restricts the federal immigration power as to people who are already in the country. But what about people who are outside the country? Do they have constitutional rights or not? That was very much at issue in the travel ban case, and I think that's very much still on the table. And the third thing that's still very much on the table, I think, is what power do states have over immigration? And that was discussed in the Arizona versus United case, in which the Arizona statutes were largely struck down, but I think that remains a very active question, especially with some new members on the Supreme Court. So I would suggest that those are the things that we most immediately are thinking about in terms of immigration power. Nonetheless, I think the discussion we're having here is helpful, and this is going to circle to some extent to what Professor Somin started out with. I think it's notable, really, that all four of us appear to agree on some very basic propositions here, and to disagree with the Supreme Court, even though this panel reflects, I think, quite a wide spectrum of political beliefs, all the way from Professor Somin to Dean Eastman, and I congratulate the organizers for coming up with a panel like this that really covers the spectrum like that. But nonetheless, I think we all agree that the Supreme Court was wrong in finding an inherent power rather than an enumerated power over immigration and the power to exclude. I think we all agree that, with the possible exception of me, that the core federal powers here are the naturalization power and the commerce power as augmented by the necessary and proper power. And the only discussion is how broad or narrow does that, do those powers add up to? Why does this matter? I think it doesn't matter because it doesn't matter that in the sense that the Supreme Court is going to suddenly decide the federal government doesn't have comprehensive power. But it does matter, I think, and here I want to echo something that Professor Somin said, that it does matter in the sense of how skeptical is the Supreme Court going to be of federal immigration power when it addresses the 3 points that I mentioned earlier. That is the question of how strictly to read the immigration statutes, whether there are constitutional rights to people outside the country, and what the powers of the states are. So I think that's why it's important to be having this discussion. So in a little bit of remaining time, then let me say a word on the actual topic of the panel, which is, does the federal government have a comprehensive power? So I think, interestingly, there's not that much difference between Professor Somin and Professor Blackman, despite the effort of making this a back and forth. It's really just a question of degree. They agree that the necessary and proper clause is relevant. They agree that naturalization and commerce are the powers. It's just a question of how much is on each side. Nonetheless, I'm going to try to slot myself into the middle ground between the two and say I think that's right. I think that the combination of necessary and proper, naturalization and commerce, as an original matter, does give the federal government substantial power over immigration and entry. In particular, it seems to me that, number one, to the extent that people are coming to the United States for the purpose of becoming citizens, then they come within the power of naturalization, even if they haven't applied for naturalization yet. And Congress may say certain people may or may not come to the United States for the purpose of being naturalized through our power, through Congress's power of naturalization. So that seems quite right to me, and that's a fairly broad category. Second, it does seem to me that Congress has power to control commerce between the United States and foreign nations, including the transportation of passengers between the United States and foreign nations. This is a point that follows from the Supreme Court's early decision on the Marshall Court in Gibbons versus Ogden, where the court concluded that transportation of passengers between states was within the commerce power of the Congress. And I think it follows from that transportation of passengers between the United States and foreign countries is within Congress's power, and consequently, that would be a way that Congress could address a good bit of immigration, especially in the early days when that was typically the way people got to the United States. People did not come to the United States by walking from Mexico, or principally even from Canada, but came on ships. So that could be regulated, I think, by Congress. So these two, and the add necessary and proper to that, adds up to a good bit. But it doesn't seem to me that it adds up to all. One could come to the United States under one's own power, not purchasing a ticket. You could sail a boat. Nowadays, it's a lot easier to walk or drive your own car. I think that would not come within Congress's power over commerce, at least not as an original matter. I think probably would in the modern Commerce Clause, and that's why I don't think there's any constituency on the left for this project. But I do think that it's very doubtful under the original Constitution. And similarly, you might not come here for the purpose of becoming a citizen. You might just come here in order to get away from nasty things that are going on in your own country as a refugee or the like. And if you're doing that, it seems questionable to me that Congress would have power through the naturalization clause. Now, as an aside, one power we haven't mentioned that would cover refugees is the treaty power, because nowadays there is a treaty regarding refugees, and most people believe, possibly not everyone on this panel, but most people believe that Congress has the power to implement treaties, and they have power over refugees through the treaty, through the Refugee Convention. But leaving that aside, and there was no Refugee Convention until relatively recently, then I think I have identified, anyway, to my satisfaction, an area where Congress does not have the power. Even though I agree with Professor Blackman that this is Congress's power is fairly broad here. So my final point, the executive power. Is there an executive power here? I have suggested in past writing that there is. Some things that some people said in response, including some people on this panel, have made me reconsider that, not to the extent of disagreeing with myself, but thinking it remains, I think, an open question. But let me just, in the 45 seconds remaining to me, to sketch that very quickly. The King of England, I believe, had this power, was understood to have this power. Blackstone said he had this power in the 1780s. It's true that in the 1790s, when the issue came up in Parliament, the English Parliament decided, surprisingly, that the English Parliament had this power. But it was, it seems that it was understood, at least if one credits Blackstone, that the king had this power, that is the power to exclude aliens in the English system. I do not contend that the Constitution carried over the English system in all senses, but I do contend that as to foreign affairs power, the Constitution carried over foreign affairs power of the English king to the extent it was not otherwise assigned to Congress. And this is why the president has powers that we believe to be routine, such as the power of international diplomacy, which is not mentioned in the Constitution, but was clearly a power of the English executive, and therefore is vested in our executive through Article 2, Section 1. So I think it is a plausible account anyway, and worthy of further study, whether the president, through his executive power to manage our relationships with foreign nations, and to provide and to oversee the national defense through his military powers, would have the power to exclude aliens that he feels are a threat to the United States, even if Congress hasn't acted. Now, once they're in the United States and we need Congress's support in order to act against them, as in the Alien Act, but at the border itself, does the executive power give the president some power there? I think if you want a comprehensive federal power over immigration, and perhaps many people in this room not, but those who do, as an original matter, I think that's the only possible source. Thanks.
Thank you, panel, for being on.
Do you have McConnell's paper?
I'm sorry?
Do you have McConnell's paper?
Time constraints
That's
here.
good.
As a retired person, I do what a lot of retired people do, which is to research my ancestry. I've discovered that some of them I found naturalization papers for some of them, but not all. So I think I still have a dog in this somewhere. Anyway, time for the panelists to raise issues with each other if they desire. We got maybe pass the microphone to whoever wants to start.
Oh, yeah, that's.
So thanks to everybody for their thoughtful comments. I just have a couple of brief responses to things that John said, and I do also have thoughts on some of the things that and Josh said, but I may leave that for later because I don't want to hog the podium too much. Just briefly on a couple points. With the Declaration of Independence, I don't think this can be characterized as just a policy disagreement. After all, it occurs in the long list of what they call abuses and oppression and the like that is horrible enough to justify rebellion. So it's not just a mere policy disagreement. Moreover, if the thought was that the king just had a general power over migration and to do whatever was necessary to prevent people from migrating or aliens from moving in, then of course he would have this power to block the state's naturalization laws as well. So I think the complaint here, like the other complaints in the Declaration of Independence, is that the king is not merely adopting a wrong policy, but is doing something that's well beyond what he was conceived of as having the authority to do. With respect to Madison and Jefferson, it wasn't just many years later that Madison said that the Migration Importation Clause did not mean that there was a general power to exclude migrants. He also said this in the Federalist Papers. I quote this in the paper where he specifically denied that this is a power to exclude free migrants from Europe. With respect to the debate over the Alien Act, John makes an interesting distinction between deportation and exclusion. This distinction actually is not present, I think, in most of the opposition to the Alien Act. Both Madison and Jefferson, the statements I quoted, but also in other materials I quoted, the debates over the Alien Act in Congress, where the opponents of the Alien Act from the Democratic Republican Party, led by Madison and Jefferson, repeatedly rejected the sorts of arguments that are brought up here under the Commerce Clause, Naturalization Clause, and so forth. And the whole point of deportation, of course, is to get rid of people who the federal government wants to declare their presence in the United States illegal. So it's somewhat strange to say that there's a power to exclude, but not a power to deport. That would be kind of a weird position, and it's not, in fact, the position that they took. Finally, on the law of nations, the power to define and punish, I agree that in the 18th century, the dominant view, as today, was that sovereigns had an international law right to exclude. It doesn't follow that any violation of a nation state's immigration laws is itself a violation of the law of nations. There were a great many things that under the 18th century conception of sovereign authority belonged to a particular sovereign, but it didn't follow that violating the sovereign's laws on that meant that you were a violator of the law of nations. For example, then and certainly even today, the sovereigns have a right to control violent crime within their borders. It doesn't follow that if a Mexican kills somebody in the United States, a Mexican citizen, that it's a violation of the law of nations. Sovereigns at that time were also thought to have the right to suppress speech and religion that's contrary to the ones that they wanted to promote. It doesn't follow that if a foreigner violates that law within the sovereign's authority, that's a violation of the law of nations. And I can go on with examples like this, but there is a distinction between powers that under the law of nations a sovereign is supposed to have and powers that things that where if a foreigner violates that domestic law, that means it's a violation of the law of nations. There's a final misimpression I'd like to correct, which is present not just in John's remarks, I think also in Josh's remarks as well, that under my approach that means there's no borders of any kind, and like obviously borders serve many functions other than excluding peaceful migrants. They exclude foreign armies, they can be used to exclude products under the power to regulate trade and a great many other things. And as I noted previously at the start of my presentation, there can be, under my conception, under the original meaning, a power to exclude some categories of aliens for some purposes. I mentioned the example of invading armies. There are other examples as well. Just there isn't a general federal power over immigration. If I'm correct about this, at least not under the text and original meaning.
Yeah, I want to pick up the law of nations thing because I think Ilya's appointed distinction actually cuts the other direction. Yes, the sovereign has the power to take actions against violent crimes. We implement that by use of our domestic law. So it doesn't require an act of Congress to define that as a violation of the law of nations and then punish it as a violation of the law of nations. We punish it as a violation of our domestic law. But it was always a foundational point in the law of nations that nobody had, not any nation, but not any individuals of that nation, had a right to enter another sovereign's territory without that sovereign's consent. So that was, by definition, a violation of the law of nations. And to define the scope of that and how much authority we are going to give, I think is expressly part of Congress's ability to define and punish the law of nations. So I think the dividing line on the examples he gives actually proves the point. There's very little issue about the migration and importation clause. Obviously, the extent of the debate in the Constitutional Convention focuses on slavery. And we get this clause as a temporary protection largely for South Carolina and Georgia, because they won't enter the Union without it. They won't ratify the Constitution without it. So the question is how much the scope is. The addition of the word migration comes without any debate whatsoever on August 25th. But also on that day, Gouverneur Morris, who is one of the leading arguers of various things in the Constitution, he specifically referred to this clause as a limitation on Congress's power of naturalization, which I think lends very strong support to my point that this is a lesser included authority under the power of naturalization. Madison in 1819, in the letter that Ilya cites in his letter, he actually goes further than Morris did. He treats this not just as a limitation on an power that we would have to find elsewhere, but is itself a grant of power. You look at the next clause in that section of the Constitution, Article 1, Section 9, it says there's no power to suspend the writ of habeas corpus, except, there's exception clause. That also looks like a restriction on the power. But there's no power in Article 1, Section 8, no enumerated power to suspend the writ of habeas corpus either. And so both of these clauses recognize, or in Madison's language, grant the power to suspend the writ of habeas corpus or the power to limit the migration and importation of persons. Now, I think with the migration importation, there are other clauses that actually confer that power. I don't need to rely on Madison's view that this was a conferral of power itself once the limitation was expired. But that's what Madison sets out in the next part of the letter that he really relied on. I think, those things combined, and when you add to it the necessary and proper clause. And let me just make one last point. There's another case that we didn't talk about earlier, the head money cases. And I think this goes to the point that Ilya's point that we didn't have this power for the first 100 years, and so we can get along without it. And he's got lots of quotations in his paper by Jefferson and others saying, we need migration. Well, again, the difference between the legal authority and the policy dispute. We needed migration because we had a vast continent that was unpeopled, except for the indigenous folks through all the years. And so they wanted larger migration. That doesn't go to the question of whether there was the authority either to authorize those migrations or to restrict them if it became problematic. And the head money cases points that out. The head money case is dealing with the commerce power to impose a tax on passengers. And the court specifically says that we're not dealing with folks coming just across the border on their own, but it doesn't challenge Congress's authority to have limited that as well. It says they haven't done it in this statute because that's not where the problem is. They were focusing on a different problem. And so I think the question of authority versus the question of what the policy that we wanted to advance at a particular time, it's important that we keep that distinction in mind.
Well, let me address a related point. What happens if maybe Ilya's right? I don't think he is, but let's say he's right. And as an original matter, there is no power over commerce, over exclusion. But the federal government's been exercising this power for well over 100 years. At what point does practice itself call into question original meaning? And this is a question which I think originalists do have to grapple with. There's a concept known as constitutional gloss, G-L-O-S-S. And there's the idea that if the government keeps doing something and no branch questions it for a very long period of time, then that itself adds a gloss or a layer on the Constitution. And perhaps the most famous explanation of this theory comes in a case called Youngstown, Duke Company versus Sawyer, the steel seizure case. And that case involved whether President Truman had the independent authority to take over a steel mill during the Korean War. And Justice Frankfurter said that Truman lacked that power. But there may be a case where if an executive did something year after year after year, and neither Congress nor the courts questioned it, that would suggest that that practice itself becomes part of the Constitution. We've been doing this for a long time. It's fairly well embedded in our constitutional republic. And even if we're wrong as an original matter, which I don't think we are, you still have to grapple with how do you deal with this practice. It would be extremely disruptive to start scaling back, I think as Mike said, bring back in any regard, the federal immigration power. Otherwise, restoring this power to the states could have unintended consequences. Ilya is very convinced that the 14th Amendment, which he didn't mention, would limit states' alienage restrictions. I don't know if that's correct as an original matter, but if the states do have this power, then my home state, Texas, can start doing a lot of things they can't do right now with immigration. And John's home state, California, could basically just open up the borders wide away. So I think we'd have a very different republic. But a key aspect of naturalization is uniformity. Uniformity. I think that's reason enough for Congress to preempt divergent state laws to ensure we have a uniform rule of naturalization where one state doesn't have a flooding open borders, the other state has a 3,000-foot wall. So if nothing else, I think past practice and our current situation reaffirms the fact that we do need a uniform federal exclusionary power over these matters. Mike?
Thanks. I wanted to just say a word to follow up on that on the states. I think it's important to keep in mind that if it's true that the federal government has an incomplete power over entry and immigration, that in our constitutional structure, that means that that power goes to the states. The states have the powers that are not delegated to the federal government under the 10th Amendment. And so the consequence of it being correct that the federal government had, that there are gaps in federal power, is that those powers go to the states. Now, Professor Somin has some, what I regard as somewhat fanciful arguments, at least as couched as originalist arguments for why the states are limited on this point. I think it's quite unlikely that the 14th Amendment limited the state power. As both papers acknowledge, the states did broadly exercise powers over immigration, over entry, in the first 100 years of the Constitution's existence. Whether that meant the federal government didn't have the power or the states were simply acting in the absence of federal activity, it's a different question. But the states were quite well understood to have the power. Did the 14th Amendment broadly take this power away or limit it? Well, there's no discussion that I'm aware of any time around the 14th Amendment that suggested it was directed towards paring back the state's power over entry. So I think that's that argument doesn't. I think that argument doesn't work well as an originalist argument. It might work better as a living Constitution argument, but then it's sort of awkwardly paired with the originalist premises of the other parts of the argument. So I think what really is at stake here is talking about the scope of federal power is whether all of the power is in the federal government or whether some of the power remains to the states. And I think put that way, it's a further support for my opening comment that there's no political constituency for this line of argument because nobody wants to put this power to the various states to let Texas and California fight out what national power over immigration ought to be.
Okay, thanks. Let's go to the audience for questions. Jack, I think we had your hand up.
Thanks. These are impressive presentations. I'm not a constitutional lawyer, but I teach the Constitution and political theory. So my question comes back to what John was saying about Article 1, Section 9. That entire section prohibits a number of acts. Clearly, the founders felt there were specified powers that were reserved to the federal government, that there was a broad number of necessary and sufficient powers where states and federal government would come into conflict. And to preempt certain conflicts, they found it wise to specifically prohibit certain acts. The privilege of habeas corpus should not be suspended, no bill of attainder, limitations on capitation taxes, articles. So these are all things that were presumed that the government could do, if not prohibited. And at the top of that is the migration clause. It clearly says migration or importation, as any of the states think proper, shall not be prohibited by the Congress. That seems to presume very clearly that if not for this clause, Congress would have the power to prohibit migration as well as importation of people. Also, it clearly says they can tax the importation of people, and if they can tax it or prohibit it, certainly they could regulate it in lesser ways. Now, my real concern with this clause is it explicitly says Congress shall not prohibit. It doesn't say Congress nor the executive. So the clause seems to presume that the executive does not have this power, but the Congress refers to Congress to have the power to limit migration. So I think it's clear that the federal to limit migration, but it's vested in Congress. So my concern is, why don't you make absolute constitution?
So I think there's really two questions here. One is, if it says migration, why doesn't that mean that there's a general power over migration? And second, what about Congress versus the president? On the first point, I think I explained at some length in my presentation why that migration point does not necessarily mean there's a general power over all migration. Rather, there was or could have been a power over such migration as comes within the Commerce Clause, namely migration of persons who were also articles of commerce as indentured servants, an important category of voluntary migrants at the time, in fact, were, and indentured servitude and slavery were, of course, closely related in some ways and seen as such. In terms of whether that suggests that there's no presidential power, I've argued elsewhere in the paper in my presentation, I think there in fact is no separate presidential power to limit migration generally. Do I think there can be to limit particular categories of entry, invading armies, certain kinds of violators of international law and the like, but I'm not sure that that reference to Congress automatically means there was no power in the president, because you can imagine a situation where they didn't want Congress to exclude certain categories of people, but they were okay with the president doing it. There could be various reasons for it. In reality, I suspect that it is the case that they thought that the president didn't have that power, but I'm not sure if that can be proven from that clause alone. I think there's other reason to think that, including the reaction to the Alien Act, where the reaction was that not just the president didn't have that power to himself, but he didn't have it even when it was specifically authorized by Congress, as in the Alien Friends Act. It was.
Anybody else on that point?
I just want to add, I think it does infer that there is a power somewhere in Congress. I mean, it makes no sense otherwise. And Gouverneur Morris says this is a restriction on the naturalization power, which means it's a broader power to restrict migration than merely those dealing with commercial interactions. And I think that's important. But I also appreciate Professor Ramsey's point that this was inherent in an executive power. And so the language of Article 2 does convey inherent powers. I mean, it's not the powers herein enumerated, as it says in Article 1. It's the executive power. But I also think he's right. It's the executive power as existed, other than as constrained by different grants of power. Clearly, the executive power included the power over war, but we take a component of that and specifically remove it from the president by giving it to Congress. And so, if I'm right that this is inherent in the naturalization power, to that extent, the president's otherwise inherent authority over this question would be limited. But that would make then sense of all three clauses.
Well, the only thing I'd say in one sentence is that I agree with most of the premises of the question, but the fact that Congress has some power over migration doesn't mean that Congress has comprehensive power over migration.
Shika?
So I have a question for both Josh and Ilya. For Josh, you pretty much like make a very persuasive case that there is a power that Congress has to limit immigration. But however, I still want you to speak to whether it's an unconstrained power. So does it have plenary power, which means disregard the Bill of Rights? Obviously, that was very important in the travel ban case. So what are your views on that? And Ilya, I mean, I hope that the Supreme case large. In the Dean ruling, Kennedy was the swing vote. Would go in the travel ban case, and but very limited. He was willing to limit plenary power when to very strong ties between the immigrant and citizens in the United States. So in other words, that the only constraints on this power would be those that individual citizens and their interests impose on it, not those of foreigners. So what do you say to that?
You want to go first or shall I go?
Yeah, I'll go first. You actually answered my question with your second part of your question, Ilya. Our Constitution was designed for our people. I know that might sound like a controversial statement in certain quarters, but it was. I don't believe people outside the United States seeking entry have any right to enter. I don't think they're protected by our Bill of Rights in any way, shape, or form. I don't think that should be controversial, but it is. To the extent that a would-be immigrant has an American citizen relative, perhaps, that relative can assert the Constitution to perhaps seek family reunification. I don't know if that's correct as an original matter, but that's been the law for the last 30, 40 years in the Kleinden's case. That's why the travel ban case, I think, was a lot easier than people did. People have no right to enter. If the president and our government discriminates against people on the basis of their religion, that doesn't implicate the free exercise clause. To the extent it implicates the Constitution, it's the Establishment Clause, because that's a structural provision. And I think I've written about this in other quarters. Lots of our immigration law classifies people on the basis of religion. We have special visa permits for preachers and pastors, and it depends on how religious you are. So I don't think our Constitution affords people outside the United States. There might be, for example, the cross-border shooting, Hernandez versus Mesa. This is an awful case where a federal border official basically fired a bullet across the border and killed a Mexican national. It wasn't engaging in any wrongdoing. There might be an instance where that could constitute a Fourth Amendment seizure because he was right on the border. But as a general matter, I think they have no positive right. So to the extent that Congress does have an enumerated power over exclusion, I think the only limitation that exists is the extent to which American citizens can assert some sort of right of reunification. I don't think the alien itself has an independent right of entry. Thank you for the question. Ilya?
So this is an issue that Josh and I have debated at some length over the travel ban. Probably knows what I'm going to say, but for those who may not, I think the answer is twofold. One is when you look at the Bill of Rights, most of it, and also many other individual rights restrictions on federal power, they're not phrased, most of them, as protections either for U.S. citizens or people located in particular places. They're phrased as general limitations on government power. There are a few exceptions, like the Privileged Immunities Clause that is specifically limited to citizens, but some argue that the Second Amendment, because it's limited to the people, might be limited to Americans, but most do not have any such phrasing. They're just generalized limitations on government power, and this is understood that way at the time of the founding. For example, Nathan Chapman has shown that even when the U.S. captured pirates on the high seas, they were seen as entitled to the procedural protection of Bill of Rights, even if they were not Americans, even though they actually were violators of international law, not just American domestic law. With respect to the question of, well, there's not a right to enter the United States, obviously under the current legal framework, which I think is not going to change anytime soon, I've already said that's true, but the restriction of the Bill of Rights and other individual rights apply to federal policies that control things which are not themselves constitutional rights. For example, the Supreme Court has said there's no constitutional right to receive Social Security benefits. Congress can repeal those Social Security benefits anytime they want to, but it's still the case that if they said Social Security benefits are only available to Christians, that would be a violation of the First Amendment. If it discriminated on the basis of race, that would be a violation, and so on, and the same applies here. And maybe there's no constitutional right to enter, but the ability to structure that right is limited by these individual rights guarantees, much as the ability to, or power to structure Social Security or to exercise other kinds of federal authority.
Peter?
Yes. I wanted to ask the members of the panel, any of them, all of them, how this whole discussion of the powers to control migration and cross borders has been influenced, was shaped, not simply by the migration and importation clause, whatever role that may or may not play, but the subsequent history leading up to the Civil War, the fugitive slave law, all that, that with those controversies, because after all, we're dealing with the ability of individuals to cross borders of states, not internationally, and I think that's some disposition on this whole debate over the source of power to control migration.
Yeah, so it's an interesting question. I would say a couple things on it. One is those who argued that the Fugitive Slave Act was constitutional, or I shouldn't say the Fugitive Slave Act, because there were actually two of them, they generally argued that it was constitutional because of the Fugitive Slave Clause of the Constitution, which was seen as an independent source of federal power. It was not, I think, generally claimed that the Commerce Clause, the power over interstate commerce, gave Congress the authority to enact the Fugitive Slave Act, although you could argue, I think, that it did if you see slaves as articles of commerce, which was certainly the dominant view of the time. I do think, however, that the slavery controversy plays into an interesting way because it makes it very unlikely that the founding fathers, particularly those from the South, would have understood the Constitution as granting very broad power over movement or extremely broad implied powers of various kinds. To the extent that that was true, of course, that would mean that the federal government would have either the power to abolish slavery or at least the power to severely restrict it in many different ways, and that was certainly something that the major slave-owning states would not have signed on to. And if you look at I go through some of these cases in the paper, if you look at the cases dealing with migration in the antebellum period, where the court issued several rulings, various kinds of taxes and restrictions on shipping and the like were actually reserved to states. You do, in some cases, see this argument come up that if Congress has this power, then they also have this very broad power over interstate movement. Roger Taney, Chief Justice Roger Taney, in one case, explicitly argued this, albeit in a dissent. So I think in some ways these things are only tangentially related, but it's most definitely in the background in that sort of the devil's bargain, if you will, to allow the Constitution to be struck, but also involves various kinds of structural protections for slavery, also has implications for how broadly we can read this power, at least as an original matter.
Question for Ilya. So let's say the Supreme Court adopts your amicus brief, overturns the 1880 rulings on the Chinese Exclusion Act. Help us understand what that would look like. Would people be able to come from any country in the world to the United States without a visa, just buy a ticket, land at the airport, and start doing their thing? Would Congress or the executive have the ability to restrict what they can do when they're here, for example, work? What powers, if any, of deportation if they commit a crime, either serious or misdemeanor? What would that look like?
Yeah. So obviously a lot depends on exactly how the Supreme Court might structure such a ruling, but obviously one immediate implication is that much of the power in this area would devolve to the states, as was true in the antebellum period, with respect to restrictions on work and other things of that sort. It would be just as Congress enacts all sorts of restrictions on how Americans work and what kind of commercial transactions they do. It could enact those with respect to aliens as well. So it would depend on your view of the scope of that authority. Finally, as I mentioned before, Congress and in some cases the president would still have the power to exclude particular categories of people under other powers, most notably war powers, excluding armies, excluding terrorists, excluding spies and the like. So I think in this next 30 seconds, I can't lay out for you in anything like comprehensive detail exactly what it would look like. I think this is one of those things that if it happens at all, would be as a result of a long-term combined political and legal process. And we may not be able to, at this early date, to envision exactly what it would look like. It would not be a complete free-for-all, but obviously it would mean, and to my mind this would be a feature rather than a bug, it would mean a massive reduction in federal power to limit immigration.
I'm Daniel Fram, graduate here. Ilya, I find it a little disturbing that you would to invoke Justice Taney's reasoning as a defense of. I mean, if you were right, does that mean Lincoln must have been wrong? And would you want to read it in the Constitution by which we would have to look back and say Lincoln was wrong and the Republican Party was an unconstitutional party, as Judge Taney said? So that's one concern. Two, on the commerce question, if you would accept the indentured servant as an article of commerce, this whole conversation yesterday was about immigrants as playing this giant role in commerce. So maybe I might be being dense, but why, if we're talking about employers, reaching out and saying, I want this worker, there's some program before we assume that the reason that the person's coming is not just to, enjoy the oak trees of Virginia, but rather to get jobs. Isn't that part of commerce even if they're not indentured? And then on the executive power thing, if we're talking about spies and war, we're talking about war, and terrorists. Why not gang members? Or, the keynote speaker said that a lot of Hondurans turn out to be involved in criminal activity. So if you have to identify people by country in that way, it's unfortunate maybe, but why wouldn't that be a matter of law enforcement or protecting citizens, even if it's not war, it's against crime?
So there's several questions there, and we try to take them in the same order. When you look at power over interstate movement and the like, this is fairly distant from the main things that the Republican Party disagreed with Taney about, which were about things like whether Congress would ban slavery in the territories primarily. And given that in the territories, Congress had the same power as the state government, that's a very different thing from Congress's power within areas where the states existed. So I don't think adopting my position somehow requires you to believe that Taney was right about all of the things that he differed with Lincoln about, particularly those things that go to the core of what we today think is the important stuff that Lincoln was right about. Nonetheless, Taney was a horrible person. Doesn't mean that he was wrong about everything. For example, Lincoln asserted broad power during the Civil War to restrict civil liberties in various ways. Taney disputed him on this. It may well be that Taney was right about that, even though he was a horrible person and wrong about many other things. Of course, Taney was far from the only person who made the kinds of points that I just mentioned. With respect to, I think I may have forgotten what the second question about executive power.
Well, the second question was about commerce, but aren't the immigrants economic, we call them economic migrants?
So the reason why indentured servants were seen as articles of commerce, whereas economic migrants and such were not, is that The indentured servant was a person whom the master in effect owned, at least for a limited period of time, usually 7 years. And so the master or the employer, if you want to call him that, had a power of ownership over the indentured servant that you generally did not have over just a conventional laborer who was free to quit and who generally didn't even have an advance contract to begin with an employer in the U.S. So essentially, an indentured servant was in an important way similar to a slave in being a person at least partially owned by another person, as opposed to merely, sort of very limited employment relationship. On the issue of criminals versus terrorists and spies, I think this goes to the question of whether the person is just engaged in ordinary crime, which is within state jurisdiction, and certainly includes virtually all activities by gang members and the like, versus a person who is attacking a nation as a whole, which should certainly be true of a foreign spy, a foreign army, arguably true of terrorists, though obviously there's going to be some fuzzy boundaries there, and that the distinction between what is terrorism and what is just ordinary killing and violence is sometimes fuzzy, and it may not always be easy to figure out exactly where the boundary lies, but a drug gang where it's pretty obvious that the purpose is just to engage in violence to make money for the gang is, I think, clearly in the ordinary crime part of the continuum. But to the extent that the federal government has the ability to criminalize certain kinds of activities under other powers, it can criminalize them for aliens much as for U.S. citizens, and it can restrict the movement of aliens seeking to commit those crimes, just as it can restrict the movement of Americans where there's evidence that they're moving for the purposes of committing one of these crimes that the federal government has the authority to ban.
Okay, one more question?
Please indulge this question, even though it's somewhat tangential to the topic you were assigned, but this is my only chance ever probably to ask a panel of 4 constitutional scholars who study immigration. Birthright citizenship. What does the Constitution have to say?
Oh, these guys. Mike, John?
I think I'll take that one.
Yeah.
Only if I get a response.
Yeah, Ramsey and I disagree Professor Ramsey and I disagree about this. Look, a couple of things that are important. There are 3 debates in Congress that occurred around this question. The first is over the 1866 Civil Rights Act. The second is over the 14th Amendment Citizenship Clause. And the third is over the Expatriation Act that comes a year or 2 later. None of them dealt with the question of children of illegal immigrants or undocumented immigrants, because that was not an issue at the time. So we have to analogize from the debates they did have. What we learned in the 1866 Act, the language is very clear there. Anybody born in the United States and not subject to any foreign power shall be citizens. The language of the 14th Amendment is slightly different. Anyone born in the United States and subject to the jurisdiction thereof shall be citizens. And the question is, did that broaden the automatic grant of citizenship? Or did it parallel what was already in the 1866 Act? And I think the evidence is fairly compelling that it paralleled. The reason for the different language is because of the problem of dealing with the 1866 Act language, not subject to a foreign power, also was intended to cover Native American tribes who were separate sovereigns but were domestic powers, not foreign powers. And so if you look at the debate in the 14th Amendment, that change in the language was an attempt to just address that issue. The political theory behind it is if you're not subject to political jurisdiction, owing allegiance to this political jurisdiction, then your children are not automatic citizens. That's a different understanding of jurisdiction than we modernly have. Right now, you're subject to our jurisdiction means you're subject to our laws. Everybody is subject to our jurisdiction when they're within our geographic territory. This issue was directly addressed in the 14th Amendment, when Senator Howard said, we mean the complete jurisdiction, not such as exists for temporary sojourners. And the best way I can explain that in kind of modern language, if somebody from Great Britain comes over here on a tourist visa, they have to drive on the right side of the road, not the left side of the road. All right? They're subject to our temporary or partial jurisdiction, our geographic jurisdiction, but they are no way subject to the complete jurisdiction. And Howard makes very clear that the language they're using is to codify that complete jurisdiction. People who are part of the body politic in some measure. Now we would say modernly, those who have taken at least the step of becoming lawful permanent residents and moved their domicile here with our consent are entitled to the automatic citizenship for their children. But beyond that, whether you're here lawfully or not lawfully, there's no automatic grant of citizenship. And there's no Supreme Court case holding otherwise. Wong Kim Ark dealt and very explicitly focused on the fact that his parents were lawfully domiciled in the United States. They weren't just here temporarily. They had taken that measure of making this their home with our consent. And I think that bilateral consent piece is also built into that. So yeah, no birthright citizenship for folks who are here even lawfully, only temporarily, unless that extra measure of some measure of allegiance is part of it.
John and I have written on this and disagreed in the past, so I'll try to give a real quick response. So I agree that the framers of the 14th Amendment didn't have specifically the idea of illegal immigration before them, so they didn't have a specific intent on that. So I agree with that point. I don't agree with anything else that he said. So the language of the 14th Amendment is that there is birthright citizenship for people born in the United States and subject to our jurisdiction. So the question is, what does that mean? Well, under international law prior to the 14th Amendment, there was quite clearly the concept of territorial jurisdiction. In fact, that was the bedrock of jurisdiction at the time, was that a sovereign had jurisdiction over all things, persons within its territory. Now, there are two exceptions to that. And why would you put that subject to the jurisdiction in there? There were two exceptions to that also recognized under international law. Number one was the children of ambassadors, because ambassadors were understood to not be under the jurisdiction of the sovereign, of the foreign sovereign, even when they were present within the territory. The other is that hostile powers, even when their forces were present in the territory, were not subject to jurisdiction. So this was a way of excluding the hostile Indians who had not been brought under the control of the United States in the West. And I think this also extends, this is a little bit less clear, but I think it also extends to Indians who are not hostile, but who had treaty-based relationships with the United States that preserved substantially their sovereignty. In any event, this is the group of people who are excluded by that textual phrase, subject to the jurisdiction. Apart from that, anyone who is within the territory of the United States is subject to its jurisdiction. So that is the textual account of birthright citizenship. By extension, that would include children of illegal immigrants, unauthorized immigrants, whatever phrase you prefer, who are not within the categories of ambassadors, children, hostile powers, and so forth. Now, the other side wants to extend this by adding the word subject to the complete jurisdiction, which there is indeed some use of that phrase in the debates. But the debates are actually quite inconclusive on this point. In particular, the drafting debates of the 14th Amendment, that is. In particular, the drafting debates also appear to recognize quite clearly that the children of lawful immigrants who are not U.S. citizens would be given birthright citizenship. There is no way to understand those people as being subject to the complete jurisdiction of the United States, because under international law as it stood in the 19th century, and it still primarily stands today, people who are citizens of a certain power are subject to that jurisdiction, subject to that power's jurisdiction, even when they are overseas. And that's why the laws of the United States follow American citizens overseas when they are traveling, or indeed even when they are permanent residents of foreign countries. So you are never subject to the complete jurisdiction of a particular country, except when you are a citizen of that country in that country. But that is not the way the draft of the 14th Amendment understood that birthright citizenship would affect the children of legal immigrants. That's the proposition that was affirmed by the Supreme Court in the Wong Kim Ark case, but I don't rest principally on that because the Supreme Court said some stuff I really don't agree with in the late 1890s. But I think it follows from the text and it follows from the understanding of international law they would have. I would add one further point, which is that prior to the 14th Amendment, it was the rule in the United States that the children of lawful immigrants were citizens, even if the immigrants themselves were not. It wasn't the constitutional rule, it was the common law rule, as reflected, for example, in the case of Lynch versus Clark. If the 14th Amendment meant to change that rule, it's surprising that this was not addressed. And in fact, like I said, the draft of the 14th Amendment, I think, fairly clearly, the debates are not a model of clarity, I will say, but I think what comes through from them is that the children of lawful immigrants had the birthright citizenship. And I don't see any textual basis for distinguishing between children of lawful immigrants and children of unauthorized immigrants.
Okay, thank you, panel. I think that was a terrific discussion. And I guess we break until 11:01.
Thanks, John.
Yeah. Give you a few minutes.
Pleasure. Thanks, Ilya. Thanks, Tim or Tom, whatever your name is.
Yeah, Tom.
We clearly